It seems like it is that time. Good morning, good morning, good morning. I am Dr. Karen Lewis. I am the host of the Real on Radio show, Real People, Real Talk, and Real Estate. And today we are sponsored by Urban Real Estate School. So if you all are interested in getting a career in real estate, or if you need continuing education, we are here for you. Phone number 954-248-9149. And I am also a real estate broker. So if you're looking to sell, I am here for you. And we're going to have a great time. We have a super guest with us. And just get your pen and your paper ready. And with me, right next to me, take the mic. Bam, 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 bam.
Good morning, good morning, good morning, everyone. My name is Tanika Moses. I'm the broker of Robinburg Realty and also the proud co-host of Real Talk.
We'll get it, because we just get back, right? So we trying to figure this thing out.
Yes.
Real on radio, real people, real talking real estate.
But yes, we're going to have a very good time today, and I'm looking forward to today because I get a lot of these type of real estate deals, which is probates. So I'm excited for our guests, and I can be reached at 954-404-4646. Again, 954-404-4646. Take it away, Dr. Karen. You got to introduce our guest.
Oh, no, not me. I guess we're going to introduce our attorney. Go ahead and give your introduction, and we'll get the show on the road.
Thank you so much. I'm delighted to be here. I am Sherlon McWater. I am the attorney at McWater Law, where I practice probate, wills, estates, planning, and trust. And I'm delighted to be here. It is amazing to be on with real people on this real radio show, talking about real estate and probate. Again, I can be reached at 1-800-391-8860. And I look forward to the engagement this morning.
Okay, so we're going to just jump right in because, again, I think this is such a good topic because, like Madam Tamika said, is that one of the last 3 transactions I've had, they were probate. So kind of tell us, like, just give us, okay, here's my first question. If somebody has children, okay, and they pass away, even if they have a will, can we use that right there? Can we use a will, or do we have to? Okay, all right, so it look like we're having some technical difficulties right here. So here we go, we got it. Okay.
Yeah, just wanted to make sure you had your mic. That's it.
All right.
Yeah, we tell it behind the scenes. The attorney's so ready to talk, she didn't even have the mic up. All right then, okay, so tell us, if a person passed away and they have a will and they have children, start that process for us.
Yeah, so it's very important for our listening audience to know that if you have a will, you are guaranteed to go to probate court. A will does not, while it's a good tool, estate planning tool, it does not prevent you from going to probate court. Because what happens in probate court is the judge looks at your will and makes sure that everything that you said is supposed to happen is going to happen. And so if you have children, you have a will, they are going to have to probate that will. It goes through the process where the judge will look at it and say, this is to happen, that is to happen per your instructions.
Okay, so that's all the will does. So even this is important because there are a lot of people that think that, who I have conversations with, they think because they have a will, they don't have to go through the probate process. So what Attorney Sherlon is saying, even though you have a will, you still have to go through probate.
Exactly. The only way you will not have to go to probate if you have a will, if you do not have any assets that you're giving away. But if you're giving assets away to someone and they're listed in that will, you will have to go to probate.
Okay, so if you don't, okay, go ahead, ma'am.
I have a question. I know there are certain types of probate formalities. Could you explain what the 2 main ones are? I think there's a summary, and I forgot the other one would be.
Right, so there are 2 types of probate. One is a summary, as you said, and then there is also a formal administration. So a formal administration means that we go through the entire process. That can take up to 18 months or more, depending upon, the number of persons involved and the assets that are involved. That process includes lots of things, including putting the creditors on notice, also waiting for them to 3 months to respond, to see, and different things like that. Whereas the summary process is a summary of that, right? A very short process, much shorter. I've actually done summaries. It took one of them actually, which is not the norm, but it took 3 weeks and we were done.
Wow.
Right? And
Wow,
so
wow.
what happens is if your person has, your deceased has been dead for more than 2 years, 2 years or more, that's one way that you can go do a summary. You don't have to deal with creditors because they have 2 years. If they've not done anything in those 2 years, then guess what? Then we don't have to go through that process. There are other ways that you can go through a summary if you have a small amount. Say you have a bank account, and that bank account only has $5,000 in it. Then we go through the summary process as well. So, and even if it's just a house, if it's just a house and it's been 2 years, we will go through the summary process as well.
Okay.
Good. So, okay, so if you're going through the probate process, okay, and let me give an example, okay, not me, somebody else, okay?
Mhm.
So somebody, family member passed away. They passed away for 3 years. And they're siblings, 2 sisters and a brother. And the sister passed away after that. Is it 2 probates or is just 1 probate?
Well, what will happen if, say the mother, Miss Johnson died, she has 3 kids. Her daughter, Susan, passed away. What's going to happen when we probate Susan's estate, right? Her children are going to, will inherit everything that she owns. If a child died, then those grandchildren of that particular one will inherit their property at that point.
So
Yes.
is that, so that would be 2 probates, so do they have to pay for it or is still that 1 probate?
That's gonna be
'Cause that-
1 probate of the grandmother, right? And her property is going to go directly to her grandchildren. They don't need to probate their money in
Gotcha.
order to get that.
Got you.
Okay.
Got you. So when, as a realtor, when we get ready to, somebody comes to us and they're going through the probate process, can they still put the house, some people want to know, can they still put the house on the market for sale? Even though it's going through the process, through the probate process, and it has not been finalized, can they still put it up for sale?
That should not happen. What should happen is you're going through the probate process, so the judge now is in charge. The judge is in control. The judge determines what's going to happen. And if you want to put that house on sale, then you have to petition the court in order to do that.
I like that.
And an important part of that is a lot of times you'll have one child that's more active than another child, and they're working with you as a realtor. And we're gonna put this house up for sale, where they're not even the PR, they're not the personal representative, right? So technically, you may be the oldest child, you may be the youngest child, you may be mom's favorite child. But if you're not listed on that will, or don't have a will, and you're not the personal representative, you have no rights to go and do any of those things. Because the personal representative, some people call it the executor, in Florida we call it the PR, the personal representative, that person would petition the court and say that we'd like to sell this house. What a lot of people like to do is they would rather wait, right? If the probate is gonna end soon enough, then they would rather just wait rather than go through that formal process with the court where they're making a determination.
Yeah, because we be ready, as soon as they say they want to sell, we're ready to put the house on the market.
They say let's, you say go.
I have a situation going on with that right now. We were able to sell 1 property. Now the other, 10 different family members who are on 9 on one side and the other is 1. No, I'm going to wait it out with the other property. And now they're trying to sue her because she doesn't want to sell the other property. It's been in limbo now for almost 2 years now.
So let me tell you, you bring up a very good issue,
Right.
and that is a partition. The court is never going to make people own property with people that they don't want to own property with. The 3 of us are sisters. Our mother leaves the property to the 3 of us, right? Or she has no will, and by law, the state of Florida says it goes to the 3 of us, right?
Yeah.
I want to sell, I want my money, I'm not dealing with y'all, give me my money, and I want it now. Right? And you say, no. First of all, we don't want to sell mama's house because that's her house. We love mama. She wanted this to stay here for all of us. What I could do is I will get a lawyer, file for partition. And what the court will do at that point is say that, you know what, this house we can't divide house up, so you have to sell. So there's a very few, if any, defenses to a partition. So if somebody files and say they want to sell and the rest don't want to sell, it is very likely, highly likely, you're going to have to sell that property.
Oh, wow.
You making noise. I'm bringing somebody live on my Instagram. You making noise on my Instagram page, Kay Moffitt. Do you have a question for attorney?
Yeah, I have a question. That's why I wanted to come on.
Okay, all right, go ahead.
So I have a question. I'm dealing with a probate now, and we have where there was a deed that was issued and recorded after the person died a year after. How do you handle that?
Did you hear the question?
Yes, you said it was recorded and filed after the person died.
The person died.
When was it signed?
Everything.
She said, when was it signed, Kay?
Before or after the death?
No, it was signed while he was in the hospital, but he was out of it. He wasn't like aware of anything.
Yeah, so it is very important, any of these documents, wills, trust, power of attorney, healthcare directive, that the person is in what we call in our neighborhood, their right mind, right? They have to be in their right mind, right? And
Exactly.
if they're not, then you can contest it. And you would do that through a lawyer, with deeds. And we're, deeds in the state of Florida, we're having lots of problems. People are stealing
Right.
people's property, people are signing
Right.
documents
yes.
and things like that. So you would have to hire a lawyer and go through a court process if you want to fight the fact that the validity of that, deed actually. And, the fact that it is filed afterwards and all of those things that you're mentioning. If you would use those things to say, no, this is not a valid will. But a judge would have to make that decision. There is, most courts will allow you to file a deed after somebody's passed away, as long as it was signed appropriately with appropriate witnesses, and all of those kinds of things. So, one of the good things at my office, Make Water Law, we have free consultations. We don't charge for them. So if that is something that you'd like to reach out to us about, I'm certainly happy to review it and have a conversation with you.
Give out your number. So,
Again, we can be reached at 800-391-8860, 800-391-8860. Also, McWaterlaw.com, McWaterlawGroup.com.
you get that, Kay? 800-391-8860. And she said that she would definitely do a free consultation for people that are listening and for yourself too. Okay? Thank you for writing that in. Okay. Thanks a lot, Kay, for coming on. Bye. Okay. Here's a question. Can someone do a probate without an attorney?
Generally you cannot do a probate without an attorney, right? The courts will not allow you to do that. It's a very complicated process. And while the lawyers make it look easy, right? And you think, oh, I could just do that. It's not easy, right? And so there are lots of things, and this is one I want to tell your listeners about. Even if you're doing a will, which is better than nothing, right? You do a will and you put your son, Harry, on there as a personal representative. Instead of your other children, because he's very responsible, and he does everything that you've asked him to do. He's close to you, he knows where your documents are. But you forget that Harry was arrested when he was in college. He got in a fight with his girlfriend and she reported to the police, and he got, as they say in our neighborhood, he caught a case, right?
I like our neighborhood language.
We gotta talk our neighborhood.
He caught a case. Y'all know what we're talking about, right?
Yeah, let's keep it real. This is real people. Okay?
All right, let's go.
Yeah, Harry was convicted. And so now Harry cannot, in the state of Florida, serve as a personal representative under any circumstances, no matter what his mother put on that will. And if
Wow.
you put him on there and he can't serve, then guess what? The court is now going to have to appoint a person. So you want to make sure that, again, if you're doing this yourself, you think you're putting your son Harry, who you love, on there, your wishes will not be kept by the court because he cannot serve. I had a family where I had the mother's case and the grandmother's case. Both died, and I was doing both of their probates. And neither one of the people that they put on there could serve because they had both been arrested. And the elder said, look, that was 30 years ago. And I said, you'll have to talk to your legislator. Because these are the rules, these are the laws, they do not change no matter who we are. And what they're saying is that if you've been convicted of a felony, you cannot serve. And it does not
Wow.
matter what that, it doesn't tell us what kinds of felonies.
Wow,
So very, very important to know.
wow.
Wow.
That's good
That's
information.
great information. Most people, they don't know.
Right.
Yeah.
Well, I didn't know
And I
that.
didn't know, so I learned something new today.
Right. I definitely didn't know that one. So they can avoid a probate, not with a will, because even if someone has a will, they still have to go through the probate process. But if they have a trust, can they avoid probate?
That is the beauty of a trust. A trust avoids probate, right? You will not have to go to probate. You'll have that trust. And let me talk to you about when a trust is really good, right? So if you only have your house, if you only have that one house, that's your only asset, it's probably not worth your while to go through probate, right? Because we can do deeds to deal with that.
Mhm.
And a lot of times our people go to different lawyers and they don't tell them that you're paying me all this money to do this will and all this other stuff, when really if it's just your house you want, you could do a deed for that. It's a ladybird deed, and we can talk about that.
Right.
But the trust that you're talking about, if you have property, say, you own a lot of real estate, or you own 2 houses, or you own a house in another state and in Florida, and you die in Florida, you come to me, Sherlon, I'm good at what I do, but guess what? I cannot help you with that probate that you need to do in Atlanta, Georgia, where your other property is, because I'm not a Georgia lawyer. So what we would have to do is we would do your probate here, and then we would have to do what they call an ancillary probate in the state of Georgia. We get a lawyer there. It'll be a short process, but again, that's more money. If you have a trust, everything goes into trust, and we don't have to reach out to any other state or any other lawyer to do that. So trust can be very good for your audience, for sure.
So you're saying, but it's good for people who have a true real estate portfolio, not just that one property.
Yeah, and if they have one property and you say, I got my homestead here and I have one property in Georgia, then a trust may be good for that as well.
Exactly. Okay, yeah, because you see it so much on social media, get a trust, get a trust, get a trust. Well, you may just have that one property.
Exactly.
So is it really worth going through all of that for that one property?
Yeah.
That's great information.
Yeah, that's
Especially for your home,
Yeah.
homestead.
Wow. So if they don't have, so you don't recommend a trust if they just have one property, because you can do what we call a ladybird deed. So
it's not that I don't recommend it, because what I don't want your listening audience to leave and say,
Okay.
Shalon, you shouldn't get a trust. It
okay.
depends, right? That's the answer. That's the lawyer answer. It depends. And that's why it's so important for you to contact us regarding the free consultation to talk about your situation. Because you may only have one house, but you have all these other things that you're going to be giving away, right? Say if you have a child, the trust is good if you have children and you know you have a spendthrift child, right? You leave them some money, they're going to spend it all at one time. A will is one and done. Once you get whatever you're giving, once they get it, it's over. A will. A trust, that can go over a lifetime. That can go over years. My son will spend all the money, so what I want to do is, Sherlon, make sure that he gets every month $1,000 a month. You can do that with a trust. You can't do that with the will, because it's one and done. So, I have a daughter, she's young, and I want to make sure that the trustee, I want my daughter, she's going to go to college, she gets this. When she graduates high school, she gets this amount. When she gets that, she get married, she get another amount. So that is, trust is very good for those kinds of things as well.
Wow, I like that.
Okay.
Tell us about the ladybird deed.
So this ladybird deed can be good for lots of people. There are people who come to me and they say, Sherlon, all I have is my house. I don't have a lot of money to spend, and I just have my house that I want to give. And I said, well, what about your personal assets? What about your jewelry? Well, my daughter, she knows that she's getting that. My son, they know that. And I only have one child. All my kids are in agreement. I've written a letter. They all know what they're going to get. But it's just my homestead, which is really important. Florida has some extensive homestead laws, which is very, very important. And it tells what will happen to your homestead. You can put things in your will. If you're married and you say, my homestead is going to my children that don't belong to my husband, guess what? That's never going to happen in the state of Florida, because the laws say that cannot happen. If that's his homestead and he lives there, he gets his life estate, which leads us to this ladybird deed. A ladybird deed is it's an enhanced life estate deed. And what it says is, Dr. Karen, that's your ladybird deed. That is your house. You have no spouse, you just have some children. You're going to give this ladybird deed to your children. Your children only get it upon your passing. when you die. They have no rights to it, they have no say-so, as long as you're breathing, okay? You have a life estate, it's yours for the rest of your life. Upon your passing, it automatically goes to them, right?
Yeah.
And all they would need to do is take a certified copy of a death certificate, send it to the clerk's office, right, property appraisers, and it's theirs. Nothing else to be done. And that is a tool that's very good for a lot of our people. And people often wonder if I have a, depending upon what kind of loan I have, can I do a ladybird deed? Generally, the answer is yes, you can do a ladybird deed. It's, but I don't own it. It's your house, even though you're paying on it. And you can do a ladybird deed. Ladybird deeds are an excellent source of estate planning that, a lot of our people don't know about, right? And so we want to make sure that they do, and I'm glad that we're having this conversation. But it's only in 5 states. It's in Florida, it's in Michigan, it's in Texas, it's in Vermont and West Virginia. Those are the only states that have a ladybird deed. Now, there's some other states like Atlanta that have a very similar deed, but not the ladybird deed itself. So those of us who are in Florida, it's a good tool, and it's certainly something that you should talk to your lawyer about, and whether that's me or another lawyer. If they talk to you, say, oh, you have your house, and you know that's all you have, and they say, oh, do you want to get a trust, right? Which is going to cost you $1,000. So you can ask them, what about the ladybird deed? Would that work for me? Now, if you have children that you're going to put on there as remainders, they get it when they die, and those children, they got some serious credit problem, and a creditor maybe have some lien against them. The law does not say whether they can get that or not, but I warn my clients, be careful, right? Because if some creditor comes after those kids, they may be able to convince a judge that, that they should get that property. I'm going to argue, no, they don't, because it doesn't belong to them now. Maybe when they pass away, yes.
Yeah.
Right? And the other last thing I'd like to say about this is, at the end of a deed, you've seen the writing with rights of survivorship, right? You've seen that?
Yeah, I've seen that.
That's important. You have 3 children, and you have a son-in-law. You love him? Well, no, she loves him. You don't love him as much. So, you don't love him that much. So when your daughter passes, if your daughter happens to pass, you don't want him getting that house.
Right,
You don't have children,
right.
you don't want him to get it. So you put with rights of survivorship, so it will, when one drops off, when one passes away, it goes to the other 2, not to their heirs, or not to their husband, or whomever. Again, things that you need to discuss with the lawyer, right, to make sure. That's why people say, well, can I get this Sherlon? Do I get this? My neighbor got that. It depends. It really depends on your situation, because everybody's situation is different. And you want to be talking to a lawyer who's going to talk to you, discuss with you, not just say, oh, let me get these forms. It's, at McWhorter Law, it's about much more than the forms. It's about you. It's about providing peace of mind for your family and making sure that your wishes are taken care of.
Wow, that's good. Craig Emmanuel is on our Instagram page.
Hey,
Craig, we're not going to even, you said a name. I am not going to even call the name out. I see you. Good morning, everybody. I can't text in or anything. And if you all have any comments on my page or Madam Tamika, just please ask us and we'll ask the attorney, because she is definitely giving us some great, valuable information. Even for myself, I picked up some golden nuggets as well with that right there. Her phone number for a free consultation is 800-391-8860. Please call her. Don't think that what you have to say or the questions that you have to ask may not be important. Give her a call, because again, like I'm saying, and Madam President Tamika is saying, is that she's just giving us some golden nuggets as well.
Yes, she is. She's giving me so much information, things I didn't, I didn't know.
And she know everything. You know everything, okay?
Like, I just saw something in the paper about a developer who just killed himself, him and his wife. They were going through a divorce, but it hasn't been finalized, this whole big situation. And now the lawyers are coming out and saying, oh, she automatically gets everything. And I'm like, it's a probate, no nothing. What happens with all of that whole entire situation?
Yeah, that's the husband-wife thing in the state of Florida is an issue that you have to be thinking about. And it even goes to what we're saying about homestead. So people will say, I own this house before I married him, right? This is my house. But if I own this house, I own this property, and it's just the 2 of us, And if we haven't engaged in estate planning, remember, you say, I don't have a will, I don't have estate planning. Yes, you do. The state of Florida has a plan for you if you haven't done one for yourself. So that plan says that there's an order, a pecking order. A husband and wife, I get what you get, you get what I got, right?
Yeah.
If we have children together and no other children, then wife first, children, nothing at that point. If all of our kids are ours together. If we have kids outside of that marriage, with that homestead, what's gonna happen is the husband, he passed away, the wife is gonna get a life estate. She get to live in it for the rest of her life. Or she can choose, you know what, I don't wanna live in it, I wanna get my money out, right? So we sell it and I get a certain percentage, and those outside children will get a percentage as well, right?
Wow. You want to say something, because we got a few minutes.
No, go ahead.
Okay, this is
that's
good.
interesting.
So I'm gonna make it short. I saw a situation where, what you said, this couple was married. They had a daughter outside. She was about 30 years old. The husband went into a reverse mortgage, but he never let the wife know that he was in a reverse mortgage. And he signed as single. Now, the wife was going through probate, and the daughter was fighting her. They did tell her that she could live in the house, but at that point, she didn't want to live in the house, so they were talking about selling it. But the daughter didn't want to, agree with her or do anything with her, so they ended up losing that house right there. I don't even think, they started the probate process, but they didn't finish because the daughter did not want to participate. And the wife didn't want to live in the property because if she had lived there, she was going to probably have to spend maybe about $30,000 to get the property up to par. So they lost it.
Yeah, but that wife, I'm not sure of the circumstances, what the wife could do in a circumstance like that, go through with the probate, right? Go through the whole process, and the judge is gonna give it to her, she get a certain percentage, right? And the daughter get a certain percentage. If she doesn't show up for her percentage, that's, another issue. But that house still could be sold, and that wife still could get what was due to her.
Wow.
She didn't know.
Right,
Exactly.
And that's
She
so
didn't
key,
know.
right? We don't know. We don't know what we don't know.
Wow.
And so what we need to do is stop going to the internet thinking that we know. I
Oh my
see that
God.
so much with people with their properties, you don't wanna pay. It sounds mean, but let me tell you what I tell people. As a lawyer, you could pay me now, you could pay me later. But generally, you're going to have to get professional help. And a lot of times our people don't want to get the professional help. But to our credit, I was reading in preparation for this, since COVID, because we look at everything pre or post COVID. In terms of persons who have done more estate planning, more wills, people of color, Black people. Black people the numbers have gone up by 20% higher than anybody else.
Oh, that's awesome.
Yeah, it is.
That's good.
It is.
That's good.
Excellent.
Because reality sets in. I was telling people, I was like, we're going to see this influx of inventory that's going to have to come on the market due to the fact that there were the breadwinners who more than likely passed away from COVID.
And we're as you can see that we're changing.
Yes.
And so we're trying to get to the information. It's time for us to get off there. We got a minute. But stop going to the internet for everything, thinking that you have your answer when it comes to wanting to buy or sell a house, especially information about probate. It's our time up now. God, this is good. Oh my God. Let me just go ahead. I am Dr. Karen Lewis. I am licensed real estate broker, and I am here for you if you're interested in selling your house. And thank you for joining us every first and third Saturday at 10:30 a.m. It is The Real on radio, real people, real talk, and real estate. 954-371-4021. And if you're interested in getting your real estate license, give us a call, because we are looking for more professional realtors out there. And my co-host, and we want Attorney Sherlon to give her number again.
Yes, you got to give her phone number again. Again, my name is Tamika Moses, broker, owner of Robin Burr Realty. You can reach out to me at 954-404-4646 if you're looking for anything in commercial real estate to purchase, lease, or sell, or also any type of residential investment property.
It has been such a delight to be here with you this evening. To your listening audience, you can reach me at 800-391-8860. I am Sherlon McWhorter. I do everything estate planning, probate, right? Nothing else. I'm a former county court judge who's doing all kind of criminal work and things like that, but at this phase in my life, Just
You
so
like,
you know.
you like, I'm not with that.
Just so you know, all I do, and I think that's a good thing for our listeners, that's a good thing for the people that I work with. I'm not juggling, I'm not doing 100
Right.
different things.
Yes,
I'm
that's
doing
powerful.
estate
Yes,
planning,
you're proud
and
and
those
focused.
kinds of things. So I look forward to hearing from some of you. If you're on and you're listening, please let me know that you heard me on Real Talk, okay, with real people. Thank you so much.
All right, thank you all so much. Make it a great Saturday, and we are signing off.
Bye, everyone.
Bye-bye.